Hello friends, in the series on the income tax cases today we will discuss the case of MEHALA machines, India and others versus income tax officers and others, and this case has been reported in 455 ITR at page number 20. The matter has been decided by Madras High Court and the date of the judgment is 20th April 2023. Friends, again this case is on section 276B, which talks about failure to pay to the credit of the central government under chapter 12D or chapter 17B. There is one more section, that is section 278B, which talks about offences by the companies. As all we know, if the company defaults into the payment of the TDS on time, then the principal commissioner can launch the prosecution proceedings against the assessee. When the offence is committed by the company, then every director of the company cannot be prosecuted. He can be prosecuted only if he is involved in day-to-day affairs of the company, he is responsible for the conduct of the business, and he should be the principal officer of the company as per section 2, clause 35. And the second issue is that whether before launching the prosecution, the separate notice to the director should be issued and show cause notice is issued to him that whether you are a principal officer or not, why you should not be treated as a principal officer, and why the prosecution proceeding should not be initiated against you, whether a separate notice to the director is necessary or not, or if the department issues the notice to the company, whether it will be deemed as a notice to all the directors or not. This is the point of discussion in this writ petition. The directors of the company went into the writ petition and pleaded that the separate notice to declare us as principal officer of the company was not issued, so this prosecution is bad in law. For this, it was the contention of the Honorable Madras High Court that there is no law that the separate notice to each of the directors should be issued for launching the prosecution. If the notice to the company has been issued, then it is a well good notice and it should be deemed that it has been issued to all the directors. Friends, with the due respect to the Madras High Court, this is very harsh because it may happen that there are number of the directors who are not being even informed about this notice. So in that cases, there will be non-compliance on the part of the directors who are not able to know about this thing. So in this case, the Madras High Court said that even if the notice has not been separately issued to the directors and it has been issued to the company, then it is a due compliance of section 276B and the department was justified in launching the prosecution. The second point on which the assessee was contesting its writ petition was that the permission for launching the prosecution was not given within 60 days by the principal commissioner. So on this point also the Madras High Court said that whether the permission has been given in 60 days or not, and whether the time taken by the assessee for giving its submission should be excluded in calculating the period of 60 days, again is a matter of fact which cannot be decided into the writ petition. Again, with due respect to the Madras High Court, in the fiscal laws there are some points and there are always some points which involve the facts. So if on this basis that facts are involved, the decisions of the writ will come, then it will be very harsh for the assessee because in every case some facts are involved. So all the writs will become liable to be rejected according to this general rule by the Madras High Court. So the main lesson from this case is that now the prosecution provisions are very harsh. If they are initiated against a director, then the director has to face the trial, and in trial generally there takes a lot of time and lot of energy in the form of money, in the form of time. So these provisions are very harsh. At the end of this video, once again I am repeating The name of the case is MEHALA Machines India Limited and others versus Income Tax Officers and others, and this case has been reported in 455 ITR at page number 20. The matter has been decided by Madras High Court and the date of the judgment is 20th April 2023. Thank you friends.